Good afternoon, everyone. Virgo here. It is September 25th, 2019. Happy Wednesday to everyone. And I have an update for you guys on the H.A.TucciJarraf and Randall Keith Beane case. All right. So as you guys are, most of you anyway, are aware, H.A.TucciJarraf and Randall Keith Beane were tried together on an indictment from 2017. They actually ended up going into court and being tried and found guilty and sentenced in 2018. And this is actually the outcome of their appeal. The United States Court of Appeals for the Sixth Circuit has published this. And I'm going to go ahead and read through it. Now, for those of you that are not familiar with this case, all of the information in here provides you with an outline of exactly what happened. So I'm going to read through the whole thing for you. And then I will link in the description for you where you can locate the PDF if you would like to have a copy of this for yourself. So let's get started. United States of America versus H.A.TucciJarraf and Randall Keith Beane. Faced with financial challenges and rising unpaid bills, the individual has two legal options: shed the debts through the humbling act of filing for bankruptcy, or find a new source of assets. Randall Beane, with H.A.TucciJarraf's assistance, tried to find a new source of assets, an alleged trust fund of government money in his name. But the money was not his, and along the way, the two of them defrauded the United States of $31 million. At their resulting criminal trial, they each asked to represent themselves, a request the court honored after holding a hearing on the matter. The trial did not end well for either of them, as the jury rejected their array of fringe conspiracy theories. On appeal, they argued that the trial court should have forced them to accept counsel in view of their unusual beliefs, because they knowingly and intelligently made this choice, and because self-lawyering does not require the individual to subscribe to conventional legal strategies or other orthodox behavior, we affirm. For years, Randall Beane honorably worked for our country, serving as an Air Force electrical engineer. At some point, he became convinced that the government was spying on the public, prompting a self-described quest into the world of conspiracy theories. His internet research led him to the straw man conspiracy theory. The government creates for each new citizen, the theory claims, a legal identification called the straw man that allows the Federal Reserve to hold in trust that citizen's inherent unlimited value. Proponents believe that by filing paperwork with the correct verbiage, they can tap into trust funds that use them as bottomless expense accounts. Timing is everything. This theory struck a chord when Beane, at a vulnerable time, when he owed more money than he could pay on his vehicle, several credit cards, and 4 personal loans. Before long, he came across the work of H.A.TucciJarraf, which did not help matters. A former lawyer who once worked as a prosecutor and public defender, TucciJarraf ran a website, posted videos, and contributed to talk shows about the straw man conspiracy theory. She also produced several faux legal documents that purported to allow individuals to access their secret fund accounts. Seeing TucciJarraf as a visionary who could make a difference, Beane reached out to her. She committed to help Beane dispose of his, quote, old energy and to, quote, move forward and be creative in getting his financial house in order. Beane found an outlet for his creativity. While browsing Facebook, he came across a video posted by an anonymous user under the moniker of a Batman villain, Harvey Dent. The video purported to teach viewers how to access their secret trust fund accounts. But in truth, it taught them how to commit wire fraud by exposing a deficiency in the automated clearinghouse network that banks use to transfer funds online. Beane discussed the video with H.A.TucciJarraf. She offered her own advice about how to perform the technique and directed him towards potentially helpful documents. On the evening of July 3rd, Beane gave the Harvey Dent idea a try. Logging onto his bank's website, he followed the video's instructions and entered the information that it recommended. Account number, his own 9-digit Social Security number, routing number, the Federal Reserves. Using these credentials, Beane made fraudulent payments in full on his personal loans, his credit card debt, and his car insurance. Elated, Beane took to Facebook to spread the word that he had just paid off all his debts with his trust account. Easy as this was, Beane tried it again on July 5th. This time, he bought certificates of deposits, CDs, with Federal Reserve funds. With H.A.TucciJarraf providing moral support through video conferencing software, Beane bought CD after CD. He didn't stop until his computer's mouse ran out of battery charge. Then he went to bed. Beane awoke the next morning to find over $28 million worth of CDs in his bank account. Before long, he increased the total to $31 million, and before long, he started cashing the CDs. With his debt cleared up and plenty of cash now on hand, he bought an $86,000 truck, as well as a $500,000 motorhome that had 2 bathrooms, marble floors, and a fireplace. Suspicious of his sudden fortune, one of Beane's banks froze his account. It also attempted to cancel the payments he had made on his new truck and motorhome. That's when H.A.TucciJarraf re-entered the picture. She advised Beane on how to protect his new assets by placing them in the name of trust and prepared pseudo-legal documents on his behalf. Claiming to be Beane's lawyer, she made phone calls to one of the banks and a dealership to persuade them that he rightfully owned the money he was spending. Her assurances worked, and the bank stopped canceling the payments. But just for a while. By then, as it happens, a federal investigation had happened, or begun. On July 11th, federal officers learned that Beane planned to drive off the dealership lot with his new motorhome. Officers rushed to the scene, arriving just as Beane started the engine. He refused to exit the vehicle, and agents had to remove him. One of the motorhome's other occupants provided officers with H.A.TucciJarraf's phone number and requested that they contact her. On the phone, H.A.TucciJarraf claimed that she was, quote, planning military operations. Officers arrested her in Washington, D.C., where she had gone after contacting the Secret Service to request a meeting with the president. Beane and H.A.TucciJarraf responded to their arrests with a flood of frivolous motions. They demanded hearings on their own identities, the identities of the arresting officers, and the identity of the presiding judge. They asserted that the United States courts cannot hold anyone except by their own consent, and that the United States is a bankrupt corporation. They submitted hundreds of pages of pointless Uniform Commercial Code filings allegedly related to something called, quote, the one people's public trust. They mailed the court an itemized bill seeking payment of over $46 quintillion. On and on it went. Concerned that such conduct might confuse a jury, the judge granted a motion that barred the defendants from raising similar arguments at trial. Beane and H.A.TucciJarraf asked to represent themselves. The judge held a hearing for each of them, complete with the standard issues, inquiries, and cautions about self-representation. The defendants provided some unusual answers, but after an extended time, the judge concluded that they had knowingly and intentionally waived their right to counsel. He granted their requests. As a safeguard, he granted their request to appoint standby counsel who can help the defendant during the trial and who can take over if the judge ends the defendant's self-representation. The defendants did their best. They cross-examined the government's witnesses, introduced evidence, testified on their own behalf, and used their closing statements to justify their worldview. But their best was not good enough. The jury convicted Beane of bank and wire fraud and both defendants of conspiracy to commit money laundering. The court sentenced Beane to 155 months and ordered him to pay over $500,000 in restitution. The court sentenced H.A.TucciJarraf to 57 months. Beane and H.A.TucciJarraf have had second thoughts about representing themselves. On appeal, they argue that the trial judge should have saved them from themselves. No cause for reversal has been shown. The right to counsel of the Sixth Amendment has paternalistic and libertarian components to it. On one side, all defendants have the right to counsel in criminal cases, along with the right to have the government appoint counsel if the defendant cannot afford it. All to the end of ensuring that the government does not remove someone's liberty to live freely in society without sound legal representation. On the other side, all defendants, whether lawyers or not, have a right to represent themselves, what amounts to the right to reject counsel and to confront the government alone. Vindication of the goals of the second option often comes at the expense of the goals of the first. Look no further than one reality of self-representation to see the tension. While the Sixth Amendment guarantees a minimum level of competence that all criminal defense lawyers must meet during a criminal case, that guarantee does not apply to self-representation. The right to waive counsel includes the right to waive effective counsel. The self-lawyer thus is free to behave as the eccentric his client selected, and that is no concern of the Sixth Amendment. Let's see. Libertarian indeed. That doesn't seem like that fits there, but okay. All of this confirms that, generally speaking, the only way out of the consequences of bad representation in a self-represented criminal trial is proof that the trial court erred in letting the individual represent himself to begin with. Here are the two questions the trial court must answer affirmatively before it follows self-lawyering. Did the defendant expressly waive the right to counsel in a knowing and intelligent manner? And did the defendant have the mental competence to quarterback his own defense? If the answer to either of these questions is no, the judge must appoint counsel. In all other cases, the defendant has the right, the constitutional right, to go it alone. Knowing and intelligent waiver. The first question to answer is whether the defendants properly surrendered their right to counsel. We have oscillated on the appropriate standard of review, at times giving the issue a fresh look, at times reviewing for plain error, and at times omitting any discussion of the relevant standard. Nothing turns on this distinction here. When Beane and H.A.TucciJarraf asked to represent themselves, they received all the vetting the law requires. The judge gave each defendant a proper hearing, during which he asked and assessed their answers to the full suit of required questions. He also properly informed them of the severity of the charges against them and the risks of self-representation. Despite these warnings, the defendants remained unequivocal that they wished to proceed alone, and their answers showed engagement with the risks and challenges of self-representation. Beane concluded his relative ignorance of the rules of evidence and rules of criminal procedure. H.A.TucciJarraf recognized that despite having gone to law school and been a lawyer at one point, she'd need to, quote, refresh herself on them as well. Both defendants had the good sense to request standby counsel, even without the judge's prompting. Other facts supported the court's decision. Both defendants previously held demanding jobs. Beane was an electrical engineer, H.A.TucciJarraf a prosecutor and public defender. Both had experience representing themselves in court. Beane had done so in a civil dispute, H.A.TucciJarraf in a criminal one. The alleged criminal conduct involved complex financial activity, demonstrating that both defendants had plenty of mental acuity. And although not dispositive, it's screwing me up having all of these different cases in the middle, sorry. Neither defendant has a documented history of psychological problems. Beane and H.A.TucciJarraf nevertheless protest the knowledge and free will requirements of their waivers by pointing to portions of their hearing in which they gave odd answers to straightforward questions. When asked to be sworn in at the hearing, Beane and H.A.TucciJarraf initially replied by saying, "I am source of all that is." And H.A.TucciJarraf flags some instances in which she quibbled over meaningless turns of phrase, the difference between the, quote, true and the, quote, truthful, and the difference between, quote, pro se and, quote, pro per representation. But throughout these verbal quibbles, they listened carefully to the judge's questions and gave lucid answers. None of these answers suggested that they misunderstood the questions or had cold feet about representing themselves. Beane argues that the judge shouldn't have let him self-lawyer at the same trial that H.A.TucciJarraf self-lawyered because she once was an attorney. But Beane never thought H.A.TucciJarraf was representing him at trial. The judge indeed assured Beane that she could not do so, and Beane acknowledged as much. Maybe Beane means only to say that he foolishly adopted H.A.TucciJarraf's trial strategy, but that fact alone wouldn't justify severance, as it carries no serious risk of compromising one of Beane's specific trial rights. And even if H.A.TucciJarraf had advanced a defense directly antagonistic to Beane's, this would present an issue only if that defense had the potential to mislead or confuse the jury. No such issue arose, and at all events, Beane never asked below to serve the trials. Excuse me, let me try that sentence again. And at all events, Beane never asked below to sever the trials. Excuse me, I'm sorry, you guys. Competence. Both defendants claim that they should not have been allowed to represent themselves without a competency hearing. Mental incompetence is a high bar to clear. To qualify, defendants must lack the wherewithal to understand the nature and consequences of the proceedings against them, or to assist properly in defending themselves. Because this requires proof of a deep breakdown in cognition, even patients with chronic severe mental illness often fall short of the thresholds. Trial judges must hold a competency hearing in the context of a claim only where they find reasonable cause for concern. This demands a difficult fact-intensive judgment call by the trial court, one that generates a heap of deference. Just how much deference is up to debate. We never decided whether to review for abuse of discretion or plain error, no matter how you slice it. However, neither defendant clears either one of those lofty bars. Beane and H.A.TucciJarraf never gave the judge adequate cause to fear for their mental competence. At all stages in the proceedings, they stuck to the prescribed rules, interacted courteously with the court and prosecution, and collaborated effectively with their appointed standby counsel. The government notably had to raise only a few objections at trial, all relatively minor, and on the rare occurrence when the judge provided instruction, they heeded it without protest. Nor did Beane and H.A.TucciJarraf's defense suggest they lacked the capacity to compete with the prosecution. While they gave plenty of airtime to implausible conspiracy theories, they succeeded in other respects. During cross-examination, they asked logical questions aimed at exposing gaps in the witness's knowledge and in inconsistencies in the prosecution's narrative. During their testimony, they successfully introduced helpful biographical details, information about their upbringings, their motivations, and their histories of government service. And during their closing arguments, they clearly explained their belief system and articulated why it led them to do what they did. Sure, experienced counsel would have done a better job, but that reality doesn't show the defendants were too incompetent to defend themselves. Else lay people could never represent themselves. H.A.TucciJarraf separately challenges this conclusion on the grounds that she should not have been permitted to stand trial with or without a lawyer. But we tend to treat both claims, this one and the one just addressed, as identical. Although trial judges may from time to time impose counsel on mentally compromised defendants just competent enough to stand trial, they aren't required to paternalize defendants in this way. That leaves the main challenge both defendants raise to their self-representation, that their idiosyncratic actions and unconventional beliefs established proof by themselves of unsound mind. But if committing murder does not automatically generate a competency hearing or incompetency finding, we are hard-pressed to understand why fantastic financial crimes would automatically do so. The hard reality is that the libertarian values of the Sixth Amendment allow individuals charged with crimes to act in unorthodox ways, even if that compromises other values of the Sixth Amendment. Just as the First Amendment does not require the individual to accept the most defensible and battle-tested political views, so the Sixth Amendment does not require adherence to orthodox criminal defense strategies. In case after case, we have rejected this argument for comparable reasons. So have our sister circuits. For its part, the Supreme Court has never suggested that eccentric worldviews, standing alone, establish mental incompetence. The hard fact is that intelligent people, even very intelligent people, can believe baffling things. The same brain that allows them to be very intelligent can, when combined with financial and other stresses, trigger all kinds of irrational behavior. Count Beane and H.A.TucciJarraf among that number. Count also the thousands of other straw man conspiracy theory proponents nationwide. These individuals, of course, are misguided, some dangerously so. But that doesn't mean they inhabit a private mental world wholly divorced from reality. And it certainly doesn't shield them from the consequences of their actions. Membership in our democracy, sad to say, does not come with an unlimited trust fund, at least a financial one. But it does come with the view of the dignity of individuals to make weighty decisions for themselves. That's why they may reject life-saving health care, consent to incriminating searches, conduct their own criminal defense as they see fit, and perhaps most harmful, but rational all the same, confess to the commission of a crime. Exercising these rights sometimes costs individuals more than they could ever stand to gain. But the Constitution lets American citizens learn that lesson the hard way. H.A.TucciJarraf separately contests the two-level enhancement she received for using her special skill as a lawyer to significantly facilitate the commission or concealment of a criminal offense. We see nothing improper about this enhancement, even if the skill did not prove effective at trial. The sentencing guidelines list legal training as a, quote, special skill, and the judge did not err in concluding that H.A.TucciJarraf used the training to assist Beane in the commission and concealment of his fraud. Commission: H.A.TucciJarraf advised Beane how to perform parts of the scheme. Concealment: H.A.TucciJarraf's legal training helped her prepare documents that increased her credibility with the banks, which allowed her to delay the discovery of the fraud. Not quite so counters H.A.TucciJarraf. While she has experience as a practicing lawyer, the documents she produced and the arguments she made were devoid of real law. We agree that the arguments were frivolous, but that really does not get her off the hook. H.A.TucciJarraf's goal wasn't to fool a veteran attorney. It was to use legal jargon and official-looking documents to disorient bank and dealership employees. And she succeeded for a while. At trial, one bank employee testified that H.A.TucciJarraf's identification of herself as Beane's lawyer definitely played a role in the bank's decision not to rescind payment promptly. That sounds a lot like United States versus Cosgrove, where we upheld a special skill enhancement because the lawyer held himself out as an entity's counsel, giving those who dealt with him the mistaken impression their claims would be handled properly. So too for H.A.TucciJarraf. Sure, H.A.TucciJarraf's efforts to protect Beane failed in the end, but that doesn't prevent the special skill enhancement from applying. Even ultimately unsuccessful conduct can preclude further inquiry when it comes to crimes like conspiracy. We require only that a defendant intend to employ her special skill in furtherance of a crime. Successful or otherwise, H.A.TucciJarraf harbored just such an intent. We affirm. Okay, so as you guys can see, their appeal was absolutely denied, as most people really kind of guessed that that would be the case. So we still have Heather and Randy both serving at least 85% of their time in federal prison, and we have Harvey Dent that is free and generally attempting to scam others, at least as far up as I can count, as about a month and a half ago. Harvey continues to claim that it was really not his fault or problem. He simply made a video, they followed it, and he still currently, as far as I know, believes that there are secret squirrel accounts somewhere. For those of you that would actually like to take a look at this document, download it, print it, read it, however you would like to use it, I will link it in the description for you. And I hope that this helped for everybody who was waiting for a conclusion with regards to the remainder of information on the Heather Ann Tucci and Randall Keith Beane case. Thanks.